Good afternoon, everyone, and welcome to our fireside chat. My name is Adele Marina Rizzo. I am the head of commercial at RB British Marine UK, a shipowning company operating in dry bulk sector. It's a pleasure for me to moderate this session today, and I take the opportunity to thank Mrs. Sanjam Gupta and her valuable team for inviting me and offering me the opportunity to connect with such an outstanding group of professionals. I'm delighted to be joined by Ana Clara Nascimento and Ruchdi Maalouf. I will leave them individually to introduce themselves. First, Ana Clara.
Hello. Good afternoon, everybody. Nice to meet you all. I'm Ana Clara Nascimento. I am founding member of Vista Brazil and senior legal counsel of an oil and gas company. And I really appreciate the opportunity to be here.
Hello, my name is Ruchdi Maalouf. I am an independent arbitrator. Before becoming an independent arbitrator 2 years ago, I was working in the LNG industry. I'm a qualified solicitor in England and Wales and Ireland. And I worked in-house in the LNG industry, and I also worked in a commercial capacity, my last role being an executive role in an LNG company in Singapore. I will be focusing on FM issues when it will be my turn.
Thank you. Together, we will discuss how risk is structured, insured, and from contract drafting to real world operations. Let's kick off with Ana Clara. In every international shipping contract, the way parties address liability remain a central issue. However, the approach to contractual liability can differ significantly between civil law and common law system. From Ana Clara, from your perspective, how do these two legal frameworks shape the understanding of a contractual liability, and how do such differences influence the allocation of risk throughout the maritime chain?
Thank you for your question. Well, I think it's really important to differentiate both legal system. The civil law, usually it's a codified system, so you probably have specifically in the legislation what is acceptable or what is allowed to have in a contract in terms of allocation of liability. And on the other side, the common law usually is uncodified, but doesn't mean that there are no rules. They are mainly focused on the case law, and they have a very big history background on how those clauses they are interpreted in that legal system, such as in England. So there are some concepts, for example, that we will talk a little bit about this later, for example, the knock for knock and the fault-based regime. There are some countries, some jurisdictions that they have only the concept of fault-based regime as a rule. So whenever you introduce a new concept that probably is most likely used in common law, it could have some kind of be strange for the courts. It will be something new. And the interpretation, when you have a claim, if you have a governing law, for example, in Brazil, which is civil law, you could face some issues and some challenges how to interpret that specific allocation of liability that, for example, in English law would be completely acceptable. So in my view, it's really important when you have an agreement, we have a charter party or any other type of shipping contract, you need to know what is the governing law, if that allocation of liability is compatible with that specific law, or if there are any restrictions that you need to be careful about.
Yeah. Second question. How do you see the usual allocation of risk? And do you observe more balanced and collaborative approach, or the Eastern industry still tend to have a very rigid and defensive
Well, actually,
adopt?
yeah, sorry. Well, actually, I think it really depends on the type of shipping contract we are talking about as well, because you can have cargo owner with a ship owner. You can have a contract between the oil and gas operator and a ship owner with a supply vessel. So you have different standards. So for example, for BINCO is very well known and is very traditional for international industry. So whenever you have a BINCO standard template on the table for international contracts, typically it's much easier to negotiate and you don't waste a lot of time because the industry already set those standards. So you shouldn't have many problems with that. But on the other side, if you have a negotiation that a party is trying to impose their own terms and conditions and it's not aligned with the best industry practices, probably you could see some imbalance on this. So in my view, in relation specifically to allocation of liability, the knock for knock says the concept is that the other party will be exempted from the liability of your damages to your own personnel, your own property, consequential losses. But it's interesting that even in common law systems, you have some countries that deals with that differently. So for example, English law, you could have this type of clause without many carve-outs. It's basically saying that you will not be liable for damages to my personnel and my property, regardless the cause, even negligence, and this would be acceptable. However, there are some other countries, for example, Brazil, I have seen some case law in US and Norway as well, that there are some restrictions when it comes to willful misconduct. And also there are some discussions in case of gross negligence. So even though that you may have this provision that doesn't carve out willful misconduct and gross negligence, depending on the governing law, you could be exposed to that clause being challenged in courts. So I think it really depends how the parties they are willing to have that business, if they are aware of those potential gaps and fragilities.
Yeah. And we come to a very big topic, insurance. So how do you see, how important from your point of view is the insurance to manage the risk? So,
sure. Well, in the shipping industry, everybody knows there are a lot of risks involved.
Yeah.
The vessel,
Yeah.
potential pollution, people, personnel, so environment. And so there are a lot of risks involved just because the vessel is shipping. So even when you're loading, unloading, so I think the most important thing is the company, it needs to be aligned, not only legal but commercial operations and insurance. Everybody needs to be on the same page, because the legal cannot give you the best advice if they don't know exactly the operation. And the same applies to a shipbroker, insurance broker, I'm sorry. So if the insurance broker doesn't know exactly the operation and the gaps and exposures, it will not be able to verify what kind of coverage you should have, what kind of policies you should have. So there are some risks that you need to add to your coverage. For example, you can have war risks or loss of hire or increase some limit of indemnification. And of course, be part of a P&I club that is renowned, like IG P&I club. So those kind of measures, it mitigates your risks. But also, I think is really, really important when we are talking about the allocation of liability is that the liability indemnities, if you have the knock for knock, for example, you need to make sure that the clause that address insurance, there is a waiver of subrogation, because otherwise it doesn't make sense. So just an example so people can understand. If I have a contract with Ruchdi and we agree that my personnel and my property is on me, and even if it happens something with my personnel that he caused, I will not claim against him. But why am I accepting this? One, because the industry is working like this and we would avoid litigation, infinite litigation. But the second thing is I can have insurance to cover this risk. So it's something predictable and you can have a price. So it's much more practical, even for commercial wise. So as soon as I have this insurance coverage, the insurance company, the event may happen, they will pay, and then it's legal that they will, as soon as they pay, they will step on their shoes, on my shoes, to try to recover this loss. So they would go after the one who caused. So imagine that I forgot to tell my insurance company that I had a knock for knock with him, and then something happens, they pay, and they go after him. And he will say, well, but I agree with Anna. She wouldn't go after me, so it doesn't make sense that you, as subrogation rights, go after me now. So those kind of things would avoid a lot of gaps and miscommunication. This is one of them, and making sure you have the insurance coverage for the risks that are aligned with the operations.
Thank you. Thank you for your intervention. And let's step to Ruchdi. Even with the strong clauses, environmental and insurance frameworks, there are moments when events move entirely behind control, when true test of risk management begins. Ruchdi, force majeure is well known in the shipping industry and international trade. Is there a standard concept of force majeure?
Thank you. I mentioned earlier that I had been involved in different aspects of the LNG industry before becoming an arbitrator. And in all these roles, I have come across force majeure, but in different ways. And in talking to you about force majeure today, I want to cover those different areas, how you see them as an arbitrator, how you see them as an operation person, or how you see them as a contracts draftsman, because they have to come together at some point. Force majeure is the point where there is a collision between reality and your contract. Yeah. And it's important to understand what it is, because we have all heard about it. We have probably all been exposed to force majeure situation through our work. But I don't think it's very clear to anyone in particular what it means. And it's not because anyone is particularly ignorant, but it's because there is no single idea of what force majeure is.
That's why we made the very basic question.
Yeah. And I would say we can probably define a concept of force majeure, and I will do that in a minute. But before getting there, we have to understand that there are two conceptions of force majeure. There is the civil law and the common law conception. And the civil law conception is a statutory mechanism that does not only apply to contract, it applies to civil responsibility as well. And it is there for certain reasons, and it is drafted in a certain way. And I did some research comparing several civil law jurisdictions and found that it had a different definition and different effect under each law. Then the common law tradition is really radically different in the sense that common law and English law has known force majeure since the 19th century, but the English judges have never accepted to define the term common law in the case law. And they have always held that force majeure is a mechanism in your contract, and it is as defined in the contract. If you mention force majeure in your contract and do not define it, the judge will not give effect to the force majeure because there is no English concept of force majeure. So these are our two traditions, but can we see some commonalities? I think the COVID FM issues, which everybody has been aware of, have shown something interesting. In civil law countries where people have relied on the law to excuse themselves from COVID circumstances, there is a tendency to reject that. Why? Because parties have not chosen FM in a civil law country if they haven't put it in their contract. But in a common law contract, of course it depends on the case, but there is no reason not to give effect to the FM clause. And generally, the FM clause will be effective if it's drafted properly and implemented properly. And so where does it live in terms of a concept of force majeure? What does it do? And this is, I think the best way to understand it is to think about what it does and not how you define it. What it does is introduce something in your contract which is to tell you what will happen in case of unforeseeability. In the same way as knock for knock will tell you, okay, if there is damage, we are going to decide that everybody bears his own damage. This is the best way to manage having 10 companies working on a project in the same site, for example. In the case of force majeure, two parties will decide that if certain things which I have not foreseen and which are not foreseeable take place, it will have a certain consequence, which the contract will spell out. So this is, for me, the concept of force majeure.
Let's go to a more specific question. So, what are the factors that most often determine whether a force majeure clause actually holds in the charter party disputes?
Well, I don't want to focus too much on the charter party dispute.
Okay.
Because there is a specificity of shipping law in relation to force majeure. Force majeure is very important in the trade contracts, and it will always be there because it's going to be the most common disruption. In my career in the LNG industry, I was exposed directly to 6 force majeure situations, and none of them went to disputes. None of them resulted in any arbitration. But this is, when things go wrong, this is what's going to happen first. There's going to be a force majeure situation. Sometimes there will be a clear force majeure situation and no declaration of force majeure. I will come to that later. So in the charter party, you also have the Hague-Visby rules or similar general exclusions that will allow you to plan for those unforeseen consequences. And these will have to work with the force majeure. Now, in terms of structure, if you are going to put a force majeure clause in your contract, you have to think about certain elements that need to be there. And these elements are there because they are the nature of the clause. So what the clause does is something happens, you cannot perform. You cannot perform, you have promised to perform, therefore you are in breach. But you have agreed that if this unforeseen circumstance event takes place, you will no longer be liable for the breach. Therefore, your clause has to define the event and explain how you will be able to assert that you are not, you are to be excused for not performing. And this is where the notice is very important. And that's why the drafting of the clause is extremely important. I mean, BIMCO has drafted a model force majeure clause in 2022.
We deal every day as a ship owning.
Yeah.
Voyage charter.
So there are certain elements in a well-drafted clause, but don't always expect the clause to be well-drafted. You will see in some, I've seen in a Russian contract a force majeure clause that would not follow any of the important facts. But the notice obligation will always be there because that's how you will implement the clause.
Yeah.
You may also have the consequences of prolonged force majeure and some termination provision if the force majeure goes on for a long time. But I would say the good practice is always to use a model when you're implementing a clause.
If I may add something. No, it's something interesting because you said unforeseeable. But for example, in Brazil, it's even more important that it's unavoidable. Because sometimes you can foresee. Yeah. For example, it's already happening. So there is COVID always about to happen, but there's nothing you can do about it, so it's still considered a force majeure. But I think it's a civil law country, and the concept is very broad. They say it's unforeseeable, unavoidable. There are some concepts that, depending on the case, even if it is not written, they can try to expand the event because it's totally new. But it would fit on that concept. So this is, I think this is the main thing in the force majeure when you have a civil law jurisdiction and common law. And civil law is usually much more broad.
Can I say something? I absolutely agree with you. The unavoidability goes to the fact that you could not, that the event prevented you from performing. And this is part of the notice. And the important thing to understand about the notice is that if you have been affected with force majeure, you have to prove it. So you have to explain how those events justify that you have not performed your contractual obligations.
When force majeure is invoked, does it still have the power to suspend or redistribute responsibility, or it's a practical effect?
The relation between the FM clause and responsibility will revolve around the actual wording. One way to look at it is that you are still in breach, but you can be excused. A pure exclusion clause will say that you have no responsibility for certain things. Force majeure says that you will not suffer the consequences of your breach. That's conceptually. The way it's drafted will not be as clear as that. But the important thing in terms of effectiveness of the force majeure clause is to realize that a force majeure event is not an objective event taking place outside. The force majeure event is relative to the relation you have with the other party. It's relative in many ways. It's relative because the factors have affected you, even though they are objective factors and they have affected other people, but they have affected you in a unique way. And it's relative because when they affected you, you reacted in a certain way, and that way may disqualify you from being able to exonerate your responsibility.
Okay.
Because you have a duty of care, you have a duty of, in LNG contracts, it's customary to make the invocation of force majeure subject to a standard of reasonable and prudent operator, for example.
The same applies for insurance, the duty of care, mitigate the losses.
Yeah.
In your opinion, how does force majeure interact with the liability insurance and environmental exposure? And how this intersection is managed commonly today?
That's...
Sorry.
I mean, I'm going to use a lawyer card. I would say it depends. But the important thing is to look at your particular situation in a constellation of contracts and legal relations and understand that these are connected, but they are not necessarily coherent. So, for example, you can have a chain of contracts in a back-to-back cargo sale, for example, but in LNG, every two companies will have a unique contract to do back-to-back sale. So you have one company selling the cargo to another company, and that company sells it to another company, and that company sells it to another company. But the cargo is going to be picked up in one place and delivered in one place. It's not going to be, it's going to be only one delivery. But each contract will be different. So a force majeure event, the delivery does not take place, and it may very well be that some contracts will allow an excuse for a party and some will not. And somebody may end up, having to pay for everything. So it's very difficult to structure your transaction in a way that's foolproof because you have all those factors and all those different companies. Yeah.
Good. I have one last questions for you, and is I guess very interesting from my point of view. What are the key issues to be aware of when a force majeure situation occurs from the point of view of an arbitrator?
Yeah.
Because he's giving us an instruction how to move.
I really have the chance of having been involved in force majeure at a purely operational level when I wasn't even in the legal function, and to look at force majeure from the point of view of a dispute. In the past 2 years, 60% of my disputes are raising force majeure issues. But when I was working in a more operational capacity, I realized one important thing which I didn't understand when I was drafting contracts. When a force majeure situation occurs, it's a problem in the operations. And when a problem in the operation happens, the operation people are talking to each other. And they are not necessarily senior managers, and they do not necessarily have a reporting obligation about every small operational incident. So, force majeure situation, what happens? One company is going to talk to the other company, manager level, saying, this happened, we have a problem, we're not sure we can deliver, etc. A discussion will start, and at that point of time, depending on the company culture and regulation, it may very well be that for several days you're going to have two junior managers talking about an issue that's actually very serious because it may result in a failure to deliver a very high value cargo. And they will exchange messages in writing, not only speaking, and they will try to resolve the issue. And it's their role. They're completely in their role trying to resolve the issue. If they do not manage to resolve the issue, the next step is going to be involving the commercial people who are behind the transaction. At that point, unless the company culture dictates it, you still don't have a lawyer in the mix. The business people are going to start to talk and find a way around the issue. So typically in LNG, you can't deliver this cargo. Okay, you deliver me a cargo next month, and I will try to find another place to deliver this cargo. It happens, you know, especially when you're dealing with very big buyers.
Yeah.
Okay. If everything is resolved at this point, they will sign the paperwork, and the issue will be done. And honestly, I've been involved in 6 force majeure issues, and none of them resulted in a dispute. They were always resolved. But if you can't resolve it at that point, and it's going to be a claim, then the legal team is going to come in. When the legal team comes in, and there's already been several days of communication, the legal manager is going to take the contract and look at the clause, and the clause will say, notice has to have these elements. And we look at the communication and see that most of the time, unless there was very knowledgeable people involved, notice requirements have not been fulfilled. This is most cases, it's most cases. So they haven't been fulfilled, and worse, in the course of the discussion between the working level, a number of admissions have been made.
Yeah.
Yeah. And sometimes they're not even genuine admission. It's just trying to show good faith in the discussion, saying, yeah, I understand, we accept that. But no, you don't accept it, but you've written we accept that because that's a way of speaking, and you've already made the admission. So in practice, the really important thing to understand is that FM in international trade starts as an operational problem involving operational managers. And if you want to catch the situation before damage is done, the system has to take this into account and ensure that when an issue happens, it is flagged so that there is no problem in notices, admissions, and which we're going to come down the line at the point of the dispute when you're going to be in arbitration or in court, and all this message will come up and undermine your position, even though you were in a good faith and in a good position.
I would like to have also Ana Clara vision as a...
No, just to add very
counsel.
Quickly, I completely agree with everything you said, and as soon as a potential force majeure happens, it's really important to reach out to legal and read the contract, because sometimes you will lose for the formality. There is notice, but this notice needs to be in writing to that specific email, and if you don't do that, you didn't notify. So, but I talked to the manager, but he's not the legal he's not the representative. It should be in writing. Those kind of things are silly, but it makes a huge difference in the end. And also, I think a good tip for everybody in every case, for any potential disputes that can happen. Sometimes we don't want to, but keep records of everything. Emails, and track them, so whenever, if you need to use them, you have proof enough to say, no, I did everything that I had to do. And even though that I didn't notify, maybe you can construe to say, but no, I notified by email and he responded, so he knew. So there are some ways to turn around the formality, but you need to be with a lot of records and documents to make your defense easier for the lawyers. Thank you.
So, thank you, Ana Clara. Thank you, Ruchdi, for your insight. Very helpful. And thank you, everybody, for your time. It's clear that managing risk in shipping is not just about writing contracts. It's a kind of a discipline, and it's also about how operators respond to the reality. Yeah. Thank you.